All right. Well, we've seen a good volume of folks signing in. Thanks again for being here. We're going to get going as some of the others start jumping on board for today's webinar. Thank you again for all of you that are already tuned in. I'm Jake Smith with the Generator team. A little bit of my background is I run some programs that are located here in the Twin Cities. In specific, I work in tandem with the University of St. Thomas, my alma mater. But don't worry, I'm not incredibly faithful, and I don't like Johnnies too. So any Johnnies that are joining, it's all good. We can still be friends. So that's a little background on me. I'm on our team that's helping deliver our emergency response program, helping facilitate some of the office hours, and helping drive the ship here today with our special guest, Bill. So you guys can read. We'll be talking about employment law and jumping into some of the details. Would really love to go over some of the, processes. So the Q&A box for those that have been here before, go ahead and type in those questions and then send them to the host. I'll be able to see those questions and can deliver them to Bill when we get to the Q&A section later on. Another tactic that'll work very easily is actually the third bullet point. You can send emails right to me, jake.smith@generator.com. If you send any emails to me there, we'll ensure that they get answered even in follow-ups if we don't get to them live. So any unanswered questions that we have either in the Q&A box or via email, we'll make sure to follow up with both of those. Bill's going to do his best to get to as much as he can. He's got a lot of content and a lot of expertise that he's going to be sharing with us. But we do have some time for Q&A at the end. So you can ask those throughout so you don't have to take personal notes and can just share questions. Just know we'll get to them later on in the webinar. And immediately following this, we'll be having our one-on-one office hours. I highly suggest finding a time to meet with someone on our Generator team. This just allows us to really get into the minutia of your situation, what you're looking at, things that you really need to be concerned about and prepared for. And we're super happy to walk through the steps that you need to do. That's no problem at all. It's our joy. And we see a lot of benefit coming from those. So if you haven't signed up, we really encourage you for a one-on-one time. In addition, we have some friends from Moss and Barnett who are going to be hosting some office hours this afternoon. So you'll get some legal advice and some one-on-one time there if you have some more complex issues or details that you'd like further discussion with that we can't accomplish here in this webinar. So that link will take you over to the office hours. You can sign up to either meet with our Generator team or with Peter, who's a lawyer with Moss and Barnett. Lastly, sorry that we can't solve all technological issues. Just wanted to give forewarning that if you're having technological issues, we can't manage just with the volume of people that are going to be tuning in, each individual technical difficulty. So if you're experiencing that, please have the confidence. These are being recorded and these will be shared to you as well. We'll have them uploaded on the Minnesota resource page following our afternoon of office hours. So just have the confidence that if you're experiencing some issues, you'll be able to get access. And lastly, I would love to give an intro to our speaker. We're super excited to welcome Bill Egan. And Bill is a partner with Avisen Legal, and he's an expert in this space around employment law and understanding how that relates directly with the CARES Act. So Bill's got some expertise that he's gotten to research over the past couple weeks and stay right on top of as things seem to change day to day. So he's got an updated information deck that he's going to be going through. And again, we're super excited to have him. So I'm going to pass it off to Bill here, and we're going to get his screen up and running. But little round of applause. We don't have the round of applause feature for the audio, but Bill, we're super thankful to have you here. Hopefully you can hear all of our thankfulness and the silent applause.
I can. Thank you. Thanks a lot, Jake. As Jake mentioned, I'm Bill Egan. I'm a shareholder with the law firm of Avisen Legal. And Avisen is a small law firm. We have 10 lawyers, and we do mostly business-related work. We help small businesses and upcoming businesses, startups, et cetera, just in terms of all of their basic corporate and business legal needs. I have been practicing in the area of labor and employment law since about 1990. Most of my work has been involved in that area. And I work both on the side of the employer and then the employee. Really, the employees are more kind of the higher level employees, executives and managers, working with them on various issues. So on the management side, I give advice to our clients regarding compliance, basically compliance issues with regard to the various state and federal labor laws and agency regulations, just in terms of complying with the various statutes and regulations that are out there. And now we have a whole new set of statutes and regulations that are governing virtually every employer in the workplace. Before I get into that, just a standard disclaimer, and what Jake said earlier about talking to the attorney over at Moss and Barnett really rings true with me. The one thing that we've determined over the last 3 weeks since these new statutes started coming into effect is that although the statutes are fairly comprehensive, as always, there are lots of different issues that arise that you can't relate directly from the statute or from going to a law firm's website or several websites to get the answers. Some of them are clear, but many of them are not, and they require a nuanced answer. So you really shouldn't rely on anything in this presentation as legal advice, because it's not intended to be legal advice. What I'm going to give you is just an overview of what Congress has provided, what Governor Walz has put into place in the last 4 weeks in terms of his executive orders, and just kind of give you an understanding of what the scope of what is out there in terms of compliance with these various statutes. So I'll start off with just a kind of a quick overview of what brought us to where we are today, and then we've got the federal response. The FFCRA is a shorthand version of the Families First Coronavirus Response Act. That was the second phase of federal legislation that was signed by President Trump back on March 18th. The requirements of that statute apply to all employers, regardless of, all employers up to 500 employees. So if any employer with 1 to 500 employees is governed by that statute. And that went into effect as of last Wednesday, April 1st. Then we had the CARES Act, which received a lot more publicity than the FFCRA. That was legislation that was enacted last week and provides various forms of relief for small businesses. I'm not going to get into too much on the CARES Act because it kind of falls outside the scope of the compliance requirements for employers. That really has more to do with what qualifications you need to get an emergency loan or this Paycheck Protection Program loan that has received so much publicity. So what I'm going to address are 2 specific provisions in the FFCRA. That's the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Amendments Act. There are a couple of exemptions that apply, one of which applies to small employers. I'll describe what the Department of Labor has come up with in the last few days on the scope of that exemption. And then in addition to the new statutes, we've also got some guidances from the Department of Labor, from OSHA, in terms of maintaining a safe workplace, managing the workplace, to reduce the risk of an infection among the workers and among customers. And then the EEOC has relaxed some of its requirements with respect to disability discrimination in terms of taking medical exams, and I'll describe that a little bit more. I'll give you some idea of what the tax relief is in the FFCRA. So there are, what you're going to hear is that employers are now required to provide paid sick leave in addition to their PTO or their sick leave policies. And the question is, well, how is everyone going to pay for it? Well, Congress has provided that with various forms of tax relief. I'm going to get into very quickly go through the emergency orders that have been put into place by Governor Walz. He's now up to 30 since he started this on, I think it was March 13th. He's got 30 executive orders in place, and then we've got some questions after that. So just in terms of the emergency declarations and kind of just let's go back, it seems like forever, but it was only a month ago that the World Health Organization declared a global pandemic. The president followed up 2 days later with his own declaration of a national emergency. And following on that was Governor Walz's declaration of a peacetime emergency for the state of Minnesota. Then it says the 11th, I think that was the 16th, Executive Order 20-03 authorized school closings. Then on the 16th, Governor Walz closed all restaurants, bars, and other public accommodations. That same day, he issued Executive Order 20-05, which expands unemployment compensation eligibility. And even if you're not applying for unemployment compensation, as an employer, it's good to know what is exactly in that statute or that executive order so that you can give some direction to employees who obviously are very concerned if they get laid off or the business closes temporarily, what their rights are to unemployment compensation. Then on the 23rd, Executive Order 2015 authorized emergency loans to certain small businesses. This is in addition to the federal programs. It's a much smaller program for the state of Minnesota, but it really was designed to support small businesses who had to close as a result of the bar closing and public accommodation closing and other businesses that were dramatically affected by that. So that's important to look into if you're looking at emergency loan relief. On the 25th, the noted Minnesota stay home order was issued by Governor Walz. That certainly impacted the businesses' availability to continue to work and blends in with all these other statutes that we're talking about. And then just a couple of days ago, he issued Executive Order 20-29, which further expanded unemployment compensation rights and obligations of employers. So I'll get into that as well. Next. Skip to the next one. We'll just keep moving forward to that, Jake. Thank you. Okay, so just in terms of the overview, we've got current laws that are in place. As I said earlier, it's important to understand that in addition to the new federal and state mandates, we also have to continue to comply with the current laws that are in place, and that is laws with respect to non-discrimination, Fair Labor Standards Act, paying employees on time, paying them minimum wage, paying them overtime compensation if they're entitled to it. None of that has changed. We just have additional requirements that are summarized here. Why don't we just skip down to the next one? I'd like to keep going so we can get to questions. Okay. This is the Families First Coronavirus Response Act. As mentioned earlier, this was the statute that was signed into law on March 18th, went into effect on April 1st. It includes two major provisions. I'll go through each of those in just a moment. And I highlighted April 1st as the effective date. And this is kind of where we get into the whole disclaimer, don't take this as legal advice. And the reason is because when Congress enacted that statute, the legislation said it was going to be effective 15 days from the date of enactment. If that was March 18th, if you use your calendar and you count, you get to April 2nd. About 4 or 5 or 6 days after the legislation was passed, the Department of Labor came out, made kind of an offhand comment that the effective date was April 1st, which sent every lawyer in the country scrambling to revise their recommendations and their advice to their employees that says, well, now it's effective on April 1st. The fact is that the Department of Labor doesn't have the authority to revise an act of Congress. And so eventually someone's going to file a lawsuit, I'm sure, at some point in time that says that employers didn't comply with the statute because it was effective April 2nd and not April 1st. And why that's important is because these leave requirements are not retroactive. So in other words, when it says effective April 1st, that means as of April 1st, you're required by law to provide certain leave relief or paid leave to employees who are affected by the COVID-19. If you've provided them with sick leave up until that point in time in anticipation that you're going to have to pay for it eventually, you don't get credit. for paid sick leave prior to April 1st or April 2nd, whatever the date that is going to be. So it's very, very important that you understand this. Virtually everybody, all of my colleagues, both in the state of Minnesota that I've spoken with and what I've read nationally, everyone's saying just go with the April 1st Department of Labor date. They're the ones that are charged with enforcing the statute, and ultimately that's the recommendation that's routinely being given. So I think for purposes of just trying to comply and be as conservative as possible, you should use the April 1st date. How to pay for this? Now, you'll see what these requirements are, and for small businesses, they can be pretty significant. The Congress has provided for tax credits, refundable tax credits available to employers to cover the amount of money that will be required that employers will have to pay to support the paid leave. But of course, that doesn't really help in terms of current cash flow. And that's where some of these exemptions come into place that I'll talk about a little bit later. Okay, emergency paid sick leave. This is the first thing that would kick in if an employee was affected by COVID-19. And I'll tell you what that means in a little bit. Covered employers, as mentioned earlier, it covers all employers of anywhere from 1 to 500 employees. There are certain small business exemptions. It is very unclear as to what those small business exemptions are and which small businesses it will apply to. I'll get into that in a little bit. And then healthcare providers are not required to comply with this statute. The obvious reason is because they want to encourage healthcare providers to staff up as much as possible. They give them the option to comply or not to comply with these statutes. Covered employees, all current employees, including part-time employees, no length of service is required. So if an employee was hired on March 29th and they get sick with COVID-19 and they go down, they get up to 80 hours of paid sick leave. Doesn't matter how long they've been there. Once you're employed on any basis, part-time, full-time, what have you, the employees are going to be covered. Emergency Paid Sick Leave Act requires that employers provide up to 80 hours, and that's for full-time employees, of paid sick leave for certain COVID-related absences. You got a part-time employee, you've got an employee that works an average of 20 hours per week, that's going to be prorated. So the employer has to provide that employee with up to 40 hours of paid sick leave. This requirement will remain in place until December 31st of this year. And that's important because a lot of people are looking at the short term, the next month or two. This is going to be something that's going to be required for the next month or two, but of course, the CDC is projecting that this could be around for a long time and affect employees for a long time. And so Congress has made this effective through the end of the year. Any unused paid sick leave, of course, is not going to carry over into the following year. This is just a special 9-month window period of time. So unlike other statute or other policies or even another state's laws, there are laws that say once you are awarded sick leave, it's considered a vested benefit. That's not the case with emergency paid sick leave. All right, this is in addition to all sick leave that's currently in effect, and employers are not to revise their current policies. So if you got an employee with 2 weeks of PTO available to them and they get the 80-hour or they get COVID-19, they get sick with coronavirus, they're going to get another 80 hours on top of their current leave entitlement. Next. Who is covered by this? So when is an employer required to pay paid sick leave to employees? It includes all employees who are subject to a government quarantine or isolation order. Not exactly sure what that means. It doesn't say in the statute, but what that is being construed as is any local government, even a state order that says that you are to be quarantined, people are to be quarantined or isolated as a result of COVID-19, they're going to be covered. So if your business requires you to close or substantially cut back on your workforce because of COVID-19. An example would be a restaurant, not necessarily closed, but all of the wait staff is laid off and half the cook staff, et cetera, because you can only do takeout orders. Those employees are going to be covered by the Emergency Paid Sick Leave Act. It also includes employees who are advised by a healthcare provider to self-quarantine. And that covers people who haven't been diagnosed, because testing is so spotty. But if you call in to follow the CDC guidelines, you feel like you're not well, you might have some of the symptoms, you call your doctor and the doctor says, yeah, it sounds like you got it, you're going to have to self-quarantine for the next 14 days or 17 days or whatever it is, then you're going to be covered by that. And the employee will be covered by that. Employers are going to say, they've already asked the question, well, how do we document that? The CDC is strongly recommending that you not require employees to provide a note from the doctor immediately. Eventually, they can do that, but because of the anticipation that healthcare providers are going to be so busy with all of this, they're not requiring that it be done immediately. But you do have to get the documentation in place in order to demonstrate, in the event of an audit or an inquiry from the government, Internal Revenue Service, that you provided the covered leave in order to qualify for the tax credit. So it's important to get the documentation in place, because you don't have to do it immediately. Again, other employees with COVID-19 symptoms and seeking a diagnosis. So if you prove that you're actively seeking a diagnosis, for maybe a couple of days, you wake up in the morning, employee wakes up in the morning and says, I think I might have it, hasn't had a chance to talk to the doctor's busy, they've got an appointment, what have you. You don't want that employee coming in. So those employees are going to be covered as well. It also covers employees who have to care for a person who either have been self-quarantined or have symptoms. Again, documentation from that family member, I misspoke there. Employees caring for a family member or another loved one, you have to show that you have got that documentation in place eventually. It also covers employees who have to care for their own children, that's primary or secondary school-age children, if their school has closed or if a child care provider is unavailable. So if you have to stay home with your kids to take care of your kids because their school is closed, then those employees are going to be covered by this as well. And then employees experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. We don't have any guidance on what that is, but sooner or later that will come out. Okay, so what do you owe? The payments are capped at emergency paid sick leave are capped at $511 a day, or $5,110 in the aggregate for employees in categories 1, 2, 3, and 6. Okay, so these are employees who either are quarantined by government order, are self-quarantined, etc. And are capped at $200 per day and $2,000 in the aggregate for employees in categories 4 and 5. And those are people who are taking care of someone with COVID-19 or have to take care of their kids while they're home from school. Again, as I said earlier, part-time employees receive prorated leave, and the average hours are, you average the hours that are covered in a 2-week period, and your look-back period is up to 6 months. Next. Notably, emergency paid sick leave does not apply to employees who otherwise have the ability to telecommute. I think that would probably exclude it. There's no specific designation, but if you're too sick to work, for example, if you're laid up in bed with COVID-19, or obviously if you're hospitalized, that doesn't apply. But, if, for example, in my situation, the governor's order 20-20 said that even though I'm considered an essential employee or essential worker because I am an attorney advising clients on their obligations at this particular point in time in history, I have to work from home because I can work from home. So the paid sick leave doesn't apply to employees who can telecommute. Employers cannot force employees to use their regular sick leave in lieu of or before they start burning down emergency paid sick leave. And the obligation to provide the sick leave ends when the 80-hour cap is reached or when a covered employee returns to work. Next. All right, the next slide is the Emergency Family Medical Leave Amendments Act. Essentially what this says is that if you have employees who are required to stay home with their kids for an extended period of time to take care of them because their school is closed or because the daycare is not operative, those employees are entitled to up to 12 weeks of emergency family medical leave. The first 2 weeks are unpaid. Then the idea is, of course, that if they're entitled to emergency family medical leave, they're also entitled to emergency paid sick leave. And so the first 2 weeks will be covered. The first 2 week gap will be covered by emergency paid sick leave. This again has a cap of $200 per day and $10,000 in the aggregate. Hopefully no one will hit the aggregate because the school is going to be closed for an aggregate of 12 weeks over the course of this pandemic, but we don't know what's going to happen in the fall, obviously. So the leave is going to be required for that amount. You've seen the definition of qualifying leave. I just described it. It's what I said earlier. Employee has to stay home to take care of a child who's sent home from school. The school is closed. And child care provider means a provider who receives compensation for providing child care services on a regular basis. If you've got a family member who is your child care provider, you don't qualify for the emergency family medical leave. Next slide. As I said earlier, the first 10 days is covered by the emergency paid sick leave, so that's not going to be compensated. The rate that you compensate is not dollar for dollar. You pay 2/3 of the usual rate of pay, and that 2/3 is capped at $200 per day. So the employees don't get their full wage if they're on emergency family medical leave. They get 66% of that. There's a non-retaliation provision in there as well that says that you cannot retaliate against an employee for taking or for asking for emergency family medical leave. That's consistent with the non-retaliation provisions in the Family Medical Leave Act. Again, it's notable, the Family Medical Leave Act only applies to employers with 50 or more employees. The Emergency Family Medical Leave Act applies to everybody, even with those with fewer than 50 employees. Now, I said earlier, there's some exemptions here, and one of the exemptions is for healthcare providers. I mentioned that earlier. I'm not going to go into detail here. If you are a healthcare provider, you can talk to your attorney about the extent of the application of that exemption. The other one is certain small businesses, and the statute itself says that the Secretary of Labor has the authority to exempt small businesses with fewer than 50 employees if that employer can demonstrate that providing the emergency paid sick leave or the emergency family medical leave would jeopardize the viability of the business. Statute doesn't say what that means. The Department of Labor has now come out with interim regulations saying what that means. They are a little bit more detailed, but not particularly helpful. I'm just going to read it to you here. Jeopardize the viability of the business, according to the Department of Labor, says that the leave would cause the small employer's expenses and financial obligations to exceed available business revenue and cause the small employer to cease operating at a minimal capacity. Those terms all are subject to great interpretation. And again, this is where you need to talk to your attorney about this, really need to talk to your attorney about this, because you're not going to get an advisory opinion from the Department of Labor on this. what you're going to get is you're going to have to make a determination as to whether you think you're going to qualify for it, and then retain documentation that shows that you believe you're qualified, and then you're going to have to ask for forgiveness at some point in time in the future. The other, another condition is if the absence of the employee or employees, so this is with respect to individual employees, would pose a substantial risk to the financial health or operational capacity because of their specialized skills, knowledge of the business, or responsibilities. So these are your key employees. And a key employee doesn't have to be necessarily an executive or someone in a high-level position. My interpretation of this is if you run a small business and you are fixed transmissions, you're a tranny shop, that's a business that hasn't necessarily been closed because it's an auto repair shop. And if you've got your emergency technicians, they would probably qualify for the exemption because you can't just hire someone off the street to come in and fix a transmission. That requires specialized knowledge. The third category would be that the employer can't find enough other workers to maintain the business and keep it as a going concern. So again, you have to talk to your attorney about the interpretation of that and whether or not you think you're going to qualify. The Department of Labor may come out with more broader guidance on that. Currently, the only exception are those related to school closings or childcare unavailability. They haven't provided any additional guidance on what small businesses will qualify. Next slide. In terms of enforcement, the Department of Labor has got a 30-day non-enforcement period. They're not going to bring an enforcement action against an employer for violating the act as long as the employer is acting reasonably and in good faith to comply. So in other words, in terms of immediate need, as long as you are trying to interpret the Emergency Paid Sick Leave Act or the Family Medical Leave Act, and you're trying to comply in good faith, a technical violation is not going to be deemed something that you would subject to a penalty or any other sort of damages from the Department of Labor. One final point is the Department of Labor has now approved a poster, just like the Fair Labor Standards Act, Family Medical Leave Act, and the various other posting requirements, notice requirements of employee rights. The employers have to post a notice of employee rights under the Families First Act in a conspicuous place on the premises. So they've approved, the Department of Labor has a form of the poster. It's a 2-pager. You just print it off in your computer. You can stick it in your break room or email it to employees as you normally do with those posters. Next. In addition to the new statutes, we've also got OSHA, guidance from OSHA. It's more common sense than anything else. Essentially, all employers are required to furnish employees with a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical harm. And that includes keeping a workplace free of hazards related to coronavirus. And then they go through a bunch of the basic infection prevention measures. You can go to the OSHA website and take a look and see what those are. They kind of mirror what is the CDC has posted on their website. Just be smart in terms of keeping your employees in your workplace free of these infectious agents. It's going to be interesting to see how all of this pans out. I heard on the news this morning that there's an individual who unfortunately worked for Walmart and passed away, and an attorney has brought a lawsuit against Walmart for wrongful death, alleging that Walmart didn't properly protect that employee from the risk of being exposed to the coronavirus and getting sick from it. Now, of course, if the employee was injured at work as a result of the coronavirus, and you can prove that the employee caught a coronavirus at work, their workers' compensation is going to kick in there. And you've probably seen some news stories about, whether or not workers' compensation will apply. But I think the greater hazard to an employer is that OSHA is going to come in and say, you didn't do enough. So I think it's important if you operate on a non-virtual basis, that you take a look at those, that OSHA guidance and the CDC guidance, and make sure that you do everything you can to cleanse the workplace of this virus. The next, next slide. Yeah, next slide after that. The OSHA also has recommendations that you develop policies and procedures for identifying and isolating sick employees. This is where it gets kind of tricky. It's a little bit different than just cleaning the counters and making sure the refrigerator is wiped down. What they want, what they're recommending is that their policy be implemented for the prompt identification and isolation of potentially infectious individuals. They cite that as a critical step in protecting the workers and customers and others at the work site. So the recommendation is that you encourage employees to self-monitor for symptoms of COVID-19 and self-report if exposed. This kind of goes outside the standard recommendations with regard to medical issues and employee privacy. Typically if the employee doesn't feel well, they just have to say, I'm under the weather and can I be excused? Well, now they're asking, they're suggesting that employers ask if employees feel like they might have COVID-19, that they let the employer know. If it's at work and the person, comes in at 10 o'clock in the morning, for example, and says, I think I've got, my chest feels tight, and feel like I might have a temperature, what should I do? They're recommending you immediately isolate that person, put them in a separate room until you can get them out of the workplace or send them home. Provide them with a face mask if feasible and available, and ask the person to wear it, and isolate people suspected of having COVID-19. Now, one question is, well, what do we do, next slide, what do we do if we have an employee who has tested positive or has been ordered by their physician to self-quarantine because they believe that they may have it, they've been exposed to someone who has it? What do we do in the workplace? We can't tell people that, they have COVID-19 because it violates their right of privacy. Well, you can certainly tell employees that you have an employee or someone who's been in the business that has been diagnosed with COVID-19 or suspected of having it without identifying the individual. Now, people may be able to draw inferences. If you've got a workplace with 5 employees and one of them's gone, and you come in and you say, well, there's an employee that may have COVID-19, you've exposed them, but it's not like, catching this illness is some sort of a, early on, I think there were some people that were overreacting to it, but now it's, it's becoming pretty common, and it's more like saying, well, so-and-so has a cold at this point in time. It's important though, it's a matter of public health, and so it's important to let employees know that they may have been exposed. So again, OSHA is not requiring that people provide doctor's notes immediately, but eventually you should have that. Let's go to the next slide. I'll try and move EEOC guidance. I'll go through this very quickly because I don't want to run out of time. The EEOC basically says that employers can't engage in medical exams in the workplace, but they've relaxed that rule in their guidance on pandemics. And this was a guidance that actually came down 10 years ago. No one really paid much attention to it because it was with regard to the N1 flu epidemic that didn't, I don't think it turned into a pandemic, but they issued this guidance in the event of a pandemic. You can measure body temperatures of employees. So you hear about employers, grocery stores, for example, that are taking the temperature of employees before they come to work. And that's just a precautionary measure. So that normally would not be allowed, a violation of the Americans with Disabilities Act. Those rules are relaxed during a pandemic. You certainly can ask employees if they're experiencing symptoms of COVID-19. You could send them home if they say they're experiencing any COVID-19 symptoms. And you can require them to remain home or remain out of the workplace until it is clear that they don't have any symptoms. You can also ask employees why they've not been at work when they return. What you can't do is you can't ask them questions that go outside of the symptomology of COVID-19. That would be deemed going over the boundaries that the EEOC has put into place. Next. Employers, again, have to maintain all information about employees in a confidential medical record. We don't see this too often, but early on after the ADA was put into place, we would find doctor's notes and personnel files. And if you have a personnel file, you maintain the normal personnel records in the file, but you also are required under the new statute to maintain doctor's notes and, relieving an employee from work and requesting or offering accommodations, all of that documentation. You have to keep a record of it. So in the event that there's an action brought against the company by a lawsuit or a government investigation, you've got records to show that you took appropriate steps. You got to keep that information in a separate medical record. Let's move on to the next slide. This is how the government is going to reimburse employers, for providing paid sick leave. The employers have to pay the cost of the emergency sick leave and the family medical leave up front. That's subject to a refundable tax credit, which is equal to 100% of the mandated paid leave amount. Yet the credit is capped at the same level where the paid sick leave requirements are capped. You obviously can pay your employees more if they're off for that period of time, but you don't get a tax credit for doing that. It's a dollar for dollar tax credit, and it's allowed against the employer's portion of FICA taxes. So that's the 7.65% that the employer pays on an employee by employee basis on FICA. That's what the credit is taken against. You don't take the credit against the employee portion. So the employee portion on the payroll of their Social Security and Medicare still gets taken out, and that still has to be paid to the government. It's just the employer's portion of it. You can withhold the credit amounts from the payroll tax payment with respect to all employees. So it's not just the employees who are affected, it's with respect to all employees. And the obvious reason is because 7% is not going to cover you. You have to use the full payroll. The employers with insufficient payroll taxes to cover the qualified sick and child care leave can apply to the Internal Revenue Service for a refund check. So you have to check with the regulations or with your accountant as to how you do that. But if you don't have enough money to cover the quarterly taxes, if you pay quarterly, in terms of to bring it back into to even, you can request a check from the government. You don't have to wait until the end of the year to get that credit. Health insurance costs are included in the credit. So, in addition to the credit on the employee wages, you also can include the healthcare costs. We don't know how that amount will be calculated because of the different calculation methodologies. Of course, we're going to get some guidance on that. It's not of immediate concern at this point in time. The immediate concern is to make sure that employees get the paid sick leave. Where the refund is owed, the IRS will send the refund as quickly as possible. We don't know what that means. Of course, we've heard in the news about the $1,200 per person checks that are going to be coming out, part of the stimulus package, and when those checks will hit is anybody's guess. Self-employed individuals also get a credit. Those are addressed in the regulations. We'll go to the next slide. These are additional tax credits for severely impacted businesses. So this is in addition to the prior tax credits. If an employer is severely impacted by the coronavirus pandemic, they're entitled to additional tax credits. The credit covers the period from starting on March 12th and runs through the end of the year, and you can get up to 50% tax credit of wages paid to certain employees. Again, you should talk to your accountant or your attorney about how to qualify for that, but there are additional tax credits that are going to be made available to employers as part of the overall relief package. The maximum credit, as noted below, though, is just $10,000 per employee. Next. Tax relief, again, the federal tax filings for businesses and individuals has been extended to July 15th. It's the new April 15th for everything. For your income taxes for 2019. The state deadlines have been moved as well. At the present, however, the estimated payments are still going to be due on June 15th. So if you have estimated payments that you make as a member of an LLC or as an LLC itself, those estimated payments are still going to be due on the 15th of June unless there's further guidance from the Internal Revenue Service. Running short on time, let's go to the next slide. Okay, this is, I wanted to get to this because it's important. Executive Order 20-05 was the order that came down in the middle of March, about the same time that the governor closed the bars. And basically it said that the Minnesota Department of Employment and Economic Development is authorized to expand its availability of unemployment compensation to people who are on an involuntary leave of absence as a result of the coronavirus situation. He indicated in his executive order who that covers. It's very similar to the coverage categories that I just referenced on the Emergency Paid Medical Leave Act. You've got your isolation or quarantine order by a healthcare provider, a recommendation to self-quarantine. If the employee is sent home by the employer due to an outbreak of a communicable disease, then they're going to be entitled to unemployment compensation. So what that means is if the employer had to cut its workforce back by 50% or 75% or even 100% due to all of this, then these employees are covered by unemployment compensation. I have several employers that were affected by this even before the order, the Minnesota State Home Order, went into effect because they were healthcare providers. And the common, about a week before that state order went into effect, most of these places stopped doing elective surgeries and procedures, and they ended up sending a lot of employees home. This executive order said that those employees also are entitled to unemployment compensation. And self-employed individuals are also eligible for unemployment. Under the executive order that came out on Monday, employers are now required to tell employees that they can apply if they're laid off, furloughed, however you want to characterize it, that they're entitled to apply for unemployment compensation. So it's not like, yeah, you know, employee, you're on your own. You have to tell them you're entitled to unemployment compensation, but it's very important not to tell them that if they apply, they're going to get it, because you don't know that. As an employer, it is not up to the employer to decide whether or not the employee is going to get unemployment compensation insurance. Odds are they will, but that's up to the state to make that determination. And the last thing you want as an employer is have an employee come back and say, well, you told me I was going to get this, and I found out that I don't qualify for it. Under Executive Order 2029, employees are also allowed to use PTO while they're on unemployment. So you've got an employee who's got, you know, let's say they've got a week's worth of paid time off that they've earned and they haven't yet used. They get laid off. What happens with the PTO? Under normal circumstances, when an employee is terminated, they get a week's pay. Their unemployment benefits don't kick in until that week's pay has been, essentially has expired. The governor's order from Monday says now you can collect your full PTO and you can still get unemployment covering that same period of time. Under the CARES Act, Congress also authorized an additional flat $600 per week benefit payable through July 31st for employees who are separated for their employment. So in addition to the state entitlement, which rule of thumb is about 50% of their normal wages up to, I think it's $600, something $610, something like that. In addition to that 50%, they get an additional $600 per week on top of that. And a lot of people quickly did the math and realized that some employees are financially better off on unemployment, at least on a temporary basis, than they would be if they continue to be employed. It's good for the employees, it's good for the economy, and it's good for the employer because none of this money is going to be charged against the employer's experience rating. This is all covered by the state and by the federal government. Next slide. Just to wrap up, the Minnesota, I just want to highlight a couple things for Minnesota employers. The Minnesota Chamber of Commerce has a really, really good website that provides a lot of information, practical information on where small businesses can go in terms of trying to see compliance with all these new statutes and regulations, and where to go for financial assistance from banks and supported by the federal government. In addition, the Small Business Administration has a small business guidance and loan resources. Again, a lot of these websites now are really, really blowing up with lots of information on all the loan opportunities that are available. I saw from an accounting firm I just saw before I logged on to the webinar, a flow chart that shows kind of what loans you would qualify for and what loans might best meet the needs of an employer who require, or business that requires some assistance. So take a look at those websites. And then I guess now we're ready for questions.
Yeah, definitely. Thank you again for going over all those. We have some questions. We'll jump right on into them, make sure that we can use our time best. Okay. First one comes from Carolyn. Carolyn's asking about individuals that might be at high risk, not necessarily showing symptoms of COVID-19 yet, but might be high risk older adults over 60 or immune compromised. If they qualify and are allowed by the employer to take unpaid time off, can they still file for unemployment for their time away from work?
No, if the employee otherwise qualifies for emergency paid sick leave, they would not qualify for unemployment, even though the governor's order indicates that you can collect PTO and unemployment at the same time. I don't know. It's a really good question because that question has not yet come up yet since the governor's order came down, and I would have to take a look at that. You can tell the employee, certainly they're free to apply, but if they're on paid sick leave, then they're not going to be entitled to unemployment compensation because they're not technically unemployed. They're just on a very temporary paid sick leave of absence. But again, the governor's order on Monday said that you can collect PTO and paid sick leave at the same time. My thinking is, I don't have the governor's order in front of me right now as I speak and answer this question, but that would just apply to the employer provided PTO pursuant to the employment policies.
Excellent. Yes.
Yep.
Continuing to move. Question that just came in from Matt. Matt says, we have a business with 10 employees, all 1099 contractors. They have not been laid off, but we did cut their contract amounts by several $1,000s. Do you recommend having them filing for either or both PPP and unemployment?
I would, yes. I would recommend them that they would both qualify potentially for PPP and or for unemployment. The PPP, the Paycheck Protection Program, is part of the CARES Act that does apply to certain independent contractors, although I've heard from a handful of independent contractors that for whatever reason they applied and their bank said they wouldn't qualify. But it certainly is worth a shot. They are independent businesses as independent contractors, and the CARES Act specifically provides that independent contractors, gig workers, et cetera, are also entitled to at least apply for paycheck protection. The governor's order did also clarify that they would qualify for unemployment, and that's also part of the $600 supplement. So they should be encouraged to apply.
Awesome. All right. We have a couple more here. There's my mouse. One that just came in from Shauna asking about the flow chart that you referenced about loans per the Minnesota Chamber site. Do you remember a specific reference there? This might be one we can come back to after the webinar too.
Yeah, I'll just say it was the Clifton Larson Allen. It's an accounting firm, and they put up a flow chart. I can't vouch for it because I didn't read through it all, certainly, and I'm not a loan specialist. But I think you'll see more and more of these flow charts that are out there. And I think if you Google flow chart and emergency loan and COVID-19 or coronavirus, you'll probably come up with several options.
Excellent. And then one last question. This one comes from Lois. Lois is curious to know, can a self-employed, sorry, just lost the message. 1 second. She's curious if a self-employed individual who qualifies for unemployment, can they still choose to receive the disaster loan?
That's a really good question. I can't answer that. I think you, I don't know. I don't know that.
Okay.
From time to time.
We're all in some boat of we're not quite sure yet, which is
exactly.
No problem. We'll follow up as info comes out on that. That answers for the most part all the questions that we've gotten to. We did have a couple around nonprofits.
Yep.
From what we understand, nonprofits are eligible to receive the same benefits. Do you have any comments on this info shared in light of nonprofits?
They are not only included in the benefits, but they're also covered under the Families First Coronavirus Act as well. So the obligations that are imposed on private employers and the opportunities for the tax credits apply to small nonprofits as well. But they are definitely included in the disaster relief program under the CARES Act. Excellent.
Awesome. Well, that wraps it up for our time here. Bill, thank you again for joining us, going over a lot of information. And to our guests, we know it's a fire hose. But if there's any more lingering questions or curiosities on what the legislation actually is saying for your business, feel free to reach out to myself, to Bill, and sign up for an office hour so we can look into what you're working on. Thank you again to everybody. We'll have this recording available posted later this afternoon. So take a second to check that out if there are pieces you'd like to circle back on. But Bill, thank you again so much.
Okay. Thanks, Jake.
All right. Bye-bye.
Bye.